The first thing I really wanted to ask you about is if you could share the where you're at with the lawsuit, the story behind the lawsuit, how this came about on your end, and a little bit deeper on some of the national support that it's been receiving, especially with these amicus briefs. We just heard about this past week.
Absolutely. I mean, it's really straightforward. I work in a clinic, the Ames Institute clinic that I co-founded a couple of years ago. I work with a naturopathic oncologist, board certified, Dr. Standish. So we get a number of patients that have different stages of cancer who come to us for integrative treatment, holistic supportive care, working with their outside oncology team. A lot of times in my role as a palliative doctor, I also help with alleviating symptoms, treating pain, or other aspects of cancer. And so many times I've been using ketamine in my practice already, which is a legally available psychedelic substance, which can have some great effects in patients with cancer or other illnesses like this, to deal with the anxiety, the stress associated with the condition, sometimes other trauma that comes up around the diagnosis or other previous unresolved issues. It can really be effective, but there's many other psychedelics out there that could have greater potency and strength, and psilocybin is one that I've been following for a long time, all throughout my training. I worked with the NYU Psilocybin Research Group when I was in residency, and got to see it up close with cancer patients who were getting recruited for the trial there. I tried to even recruit some of my own patients I was seeing there to go get that treatment, but it was very hard for access reasons, because you really had to be outpatient. You had to have a lot of support, because it's a research study and it's very controlled. So I've been, and then of course all of their publications have started coming out from the Hopkins group, the NYU group, the UCLA group before that, in the modern era, showing in controlled clinical trials that you can really make some big differences in psilocybin-assisted therapy for cancer patients, in ways that you could only dream of in palliative care, like that kind of huge, robust response that goes on for so long. So it was in my mind, and I knew that this was happening and coming about, and I knew that right to try was something that had already been adopted. I didn't really have a legal pathway to implement it, because they really weren't giving a lot of rules at the FDA how to actually get right to try access to these medicines. They just said contact the sponsors. And so when I was approached by Catherine Tucker she's an amazing attorney and patient rights advocate who's worked on a lot of issues with end-of-life care, access to medicine, to physician aid in dying, as they call it. Like that's a right that is in many states now, and it's thanks to efforts of her and her organizations that have really helped push that and say, hey, this is an option that should be available, and the federal government shouldn't step on Oregon. That's the sort of famous Supreme Court case that she worked on. So I was familiar with her, and I knew that she was working on psychedelics and palliative care as well, as interested in that. We had met at a conference a couple of years ago, and I just felt like, wow, okay, maybe, who knows, like this, she's starting a conversation in 2017 around this, psychedelics and palliative care, what would be the appropriate setting and use. And it was at the law school. Anyway, so she came back into contact with me through an organization I'm involved with here in Washington called End of Life Washington, which is an advocacy group that helps patients with end-of-life care. And they asked about, well, what do you know about psilocybin? I said, well, yeah, I mean, I think it's important medicine and can really be helpful in palliative care and suffering. And they're like, well, also we have an attorney that is looking for, who has developed a theory around the right to try, has written a law article about how to implement this, and vis-a-vis psilocybin or other psychedelics, Schedule 1. Do you want to talk to her? I was like, oh yeah, I know her, and so we talked, and she asked me if patients of mine have asked me about access to this, and I said it comes up all the time. I mean, or so often that, and people really basically know that there's no way I can prescribe it, so they stop asking about it. It's just sort of in the ether because of Michael Pollan's book and everything else. So anyway, when she asked me about this, and I did have some patients who had recently seen who really were interested in getting in, like trying to use this medicine and move the field forward to help other patients. They had this very commonly, many cancer patients, in addition to helping themselves or when they're going through their treatment, they also want to make sure that there's people behind them or their peers have the same access to the kind of medicines that they do. And so I had some patients in mind who, I was treating and were at different stages of their treatment with cancer. And I asked them if this is something that they'd be interested in trying psilocybin, and maybe if we were into problems trying to fight for it, and they said absolutely, let's do it. That sounds great. So we talked, and that's how we developed. Okay, well, what should we do? And we contacted a producer, and the producer said no, and we don't really do that. And then we looked for other producers, and then we thought, well, we should make it ourselves. And we went through all these different ideas about how to approach it, because we really think that there was a right to this. And then actually we got a lot of support early on, even from Washington State, my authority here. They said, yeah, that's fine, as long as you can get the DEA to sign off. You can cultivate psilocybin fungi and administer that. We understand it. We understand right to try. But finally, when we finally had to reach the DEA, that's when we just realized that none of the agents in our area or the ones in Massachusetts, where there was a producer of psilocybin that was then willing to supply to us if we had the right license, neither of their DEA headquarters in those locations or regional offices had any idea about right to try. A former DEA agent we spoke with, who was like a consultant to help people work with psychedelic medicines, he also didn't know how this would square with the way that the DEA approaches things. A DEA lawyer who worked a lot on the DEA, like nobody really knew, and it was just like, no, the DEA says it's only about research. There's a form, there's a box, that's all it is. That's all you can do. So they hadn't updated any of their their forms or access around the new rules, the new laws that allow access to substances. There could be plenty of scheduled substances that are being researched and would be eligible investigational drugs, but they didn't see it that way. So when we finally wrote to them, Catherine drafted a letter I looked at, and we sent to the DEA, and they basically said, yeah, we get what you're saying, but sorry, we don't, our hands are tied. We got an official letter from them saying, there's no pathway like this. Just be a researcher and do a research study, and right to try doesn't apply because of some blah, blah, blah. So that's when we, getting more and more, Catherine amassing more experts in the law who are all really working on this pro bono, or they're trying to raise their own money to support their fees. They really believe in this. They just said, this is contestable, based on the theories and understanding that we have. And that's how the lawsuit was filed, or the challenge was made. We had to wait a couple of weeks after we got the letter. There's a waiting period, and then we can go directly to the circuit court that's related to where the doctor, and my patients are residing, where I'm licensed. So that's how we got into the Ninth Circuit right away. And it's, wrote declarations. We, developed these theories. Now there's an opening brief that they've filed. And even before that opening brief, I should say, we were able to petition a motion to expedite the hearing, because there's so many petitions get filed in the Ninth Circuit Court and other courts, and there's always a backlog. But there's something special about the needs of patients with serious illness, as I was saying in the beginning, that they don't have as much the luxury of just sort of getting in line. They need to go to the front of the line. Like, this is like not it's not a first come first serve. It's like, this is their needs are very sensitive, time sensitive. So what was amazing to see for me, that I had a really grateful, hopeful thought around, was when the court said, we filed a motion to expedite the review process, expedite the entire case, and the Department of Justice lawyers didn't contest it, agreed, yeah, we should move this quickly. And the court said, okay, here's your briefs are due in May, and responses are due a few weeks after that, and responses to that are due after that, and it's like on this track. We've already now filed the openings brief, which was it's an amazing piece of writing. I think they completely looked at the whole history of drug regulation from the early 1900s to the early laws of FDA that regulated medicines for safety, and then later on efficacy, and and they talked in terms of like, is it safe? Okay, great. Then later, is it effective? Because of all the things that happen with thalidomide and other medicines. So they kind of look at that whole history and then look at the DEA's role and how they have really, DEA is not supposed to be practicing medicine. DEA is not supposed to be involved. Like the FDA laws really supersede the drug. Those laws are, DEA has to accommodate. Their only role is to stop drug diversion and like the problem of drug abuse and all that. And if there's a medically necessary, medically justified thing happening, they're not to get in the way of that. That's not their role. And that it made it very clear. They completely eviscerated the arguments that the DEA had laid out in their letter. And I just thought it's an excellent piece of writing. It's very readable. And then so that happened. And then in the meantime, all these amicus briefs that you're mentioning started getting collected, and I was blown away. I had no idea what was happening there. This is the attorneys working on this, and it turned out my own state's attorney general, got behind my argument that this is an issue that the state of Washington and our lead lawyer is backing us up on. That was impressive. These are they understood that this is a law that the Washington legislature unanimously passed. Like every legislator voted in favor of getting experimental, right to try access for these kind of medicines for patients. And here the DEA, this agency, is saying, nope, sorry, it doesn't apply for this class because of, we follow the 1970 rules, not the 2017. Like we're 50 years behind you. We haven't caught up.